This was a very damning day of evidence for Lori Vallow. I've always thought motive is the best evidence that the state has in this case. You don't have to prove motive, but when you have it, it certainly makes it a lot easier to win a case like this. So that's kind of my thought with how this day went for Lori Vallow. But there were some things that I was a little surprised at how the prosecutor handled it and how the prosecutor's strategy was throughout this day. So we're going to get into a lot of that as well.
Normally the normal 16 things that you test for?
That would be atypical.
Okay. So normally they don't ask you to do that in a common manner?
They do not know.
Okay. And so in this case, you did just test for the typical things and no other requests were made. Is that correct?
I believe so, yes.
Okay. As far as the abrasions on Charles' knees, could those have been, you said that they were consistent with having been close to the time of death. Is that correct?
They had that general appearance, yes.
And so those abrasions could have been caused by a scuffle before he was shot. Is that correct?
Yes.
And not necessarily falling forward.
So here's kind of a decent line of questioning, right? He had abrasions to his knees and his hands, I believe. And the state put their angle and their point, and the ME doesn't know, right? He's saying it's possible that these things could be consistent with X, Y, or Z. The state basically made it sound like he was on the ground, not putting up a fight. That's how he got those abrasions. Lori Vallow says, well, they could have been wrestling on the floor. He could have been crawling after somebody. It could have been a scuffle of some sort that could have caused these abrasions. Okay? Decent question for the evidence that she has. Doesn't feel like it's true, but decent question.
Forward onto his knees.
Correct.
And then the abrasions on his hands as well?
What about them?
That they could have been caused from a scuffle beforehand?
Yes.
Okay. I know that the state asked you if it was consistent with him, with the second shot, the shot to the abdomen, that it was possible that he could have been shot on the floor. Is that correct?
Correct.
But would it also be possible that he could have been falling when that shot happened as well? And then hit the floor?
Not really. If he was falling and still passing through air, not yet having hit the ground, that would not have caused a short wound.
And while the scuffle questions, I think, were decent questions, this was horrible. Stepped in it, completely missed the boat. Wild theory. This guy, I thought this guy seemed just like very smart and down the middle, and he gave everybody the truth. He was like, yep, could have been that. Yeah, could have been that. It's very possible it was this. Didn't seem overly engaged to either side. He was just giving his expert opinion. But holy cow, these questions I thought were so bad. I think completely missed the boat with the jury. And make it, when you do stuff like this, it's one thing to just ask a question where you don't get a good answer. It's another thing to ask a question that is so outlandish that the jury now starts to think, are you just making stuff up? Are you trying to trick us? Are you trying to tell us he bounced off the floor? Like, I don't understand what you're even trying to get at with these questions. And you can lose a jury sometimes with these kinds of questions.
So if he had hit the ground and bounced on the ground from the first shot, as the second shot was traveling, that could not be possible that he hit the ground when that shot was exiting the shoulder?
He would have had to have been on a firm surface to create that short wound.
And it could not
And the
be
reason he knows that is because the way the wound was, it was up against something hard. So it's different. You make the exit wound is different if I'm leaning up against this chair versus if I'm just in the air and it can exit that way. And that's how he explained it. And for her to ask like he's bouncing off of the floor, to me, that just doesn't make a lot of sense. And even if he was bouncing off the floor, the second shot was probably unnecessary if this was self-defense. Now, times are fast. It's hard, reactions. If he still has the bat in his hand, there's still a lot of things that you can argue as far as self-defense goes. But I don't even think this argument helps her at all. So I thought it was kind of strange.
Caused by tight clothing?
Tight clothing and short wounds is typically like a supportive garment, like a belt or a bra. In my experience, I've never seen it with like a t-shirt or anything like that.
Are you familiar with bamboo clothing?
I am not, no.
Or how?
Again, not just bouncing off the floor, but are you familiar with bamboo clothing? Okay. Well, again, this expert being very smart handles this perfectly and answers it perfectly. But once again, if you're the jury, are you like, Teflon bamboo, like a bulletproof vest? Was he wearing that? Is that what she's trying to say? I don't get it. I've never heard of it. If I was sitting on the jury, I'd be like, what is she talking about? And that's never a good thing if the jury's thinking, what are you talking about?
How tough that material would be?
I am not.
Okay. That's all I have, Your Honor.
All right, redirect.
And on redirect, the prosecutor gets up and says, if he was wearing bamboo clothing, wouldn't the other shot have a similar short wound? And he's like, yes, it would. Handles it perfectly. So from my perspective, that's a great way to handle even that very weird statement and argument to are made by Lori Vallow, which is again trying to be like, well, you don't know the whole story. You don't know the whole story. Sometimes that can work with some intrigue. Sometimes it falls well short. Then you got the Social Security fraud witness that just talks about how $2,000 a month for Lori, $2,000 a month for JJ, based on Charles dying. On cross, she basically says, well, you don't know what they told me. They could have told me it was just a spouse thing. I could have thought I was getting this, but really I was getting that. You weren't there in my interview, and you don't know what happens. There's a lot that could happen that you don't know. And then on redirect, the prosecutors are like, you have to actually apply for these benefits, right? You guys don't just send money to everybody. You don't know every time somebody dies, right? It's like this actually has to be applied for and granted. But what I thought was most interesting with this witness was the juror question. So yes, there are juror questions. I love juror questions because it lets you know what a jury is thinking. And then a lot of times you'll hear Lori Vallow doesn't follow up after the juror question, but you know who does? The prosecutor. Because lawyers know you learn a lot from juror questions and you want to craft your argument about what they're talking about. Now, a lot of times I say the chat, you guys are potential jurors. And we've seen lawyers in cases literally read the chat, live chat afterwards, whatever it may be, to see what people are talking about. Because if you're confused about something, a lot of times the jury will be. If you are all side-eyeing something like, is that really true? Could that really happen? Then you might want to lean into that as the lawyer. If there's something that needs to be highlighted more, you can tell in the chat sometimes. And as a lawyer, you want to highlight that. So you can learn things just like you can learn from the chat. You can learn something from juror questions during trial. The jury's not trying to tell you where they stand or where they are, but they can't help themselves when they're asking questions. You know what they're focusing in on. So let's listen to what question they asked this witness.
Were payments to Lori Vallow stopped after your investigation?
They were, yes.
How about that question? Were payments to Lori Vallow stopped after your investigation? So here's what I would say. I would object to that question if I was a defense attorney and say, Judge, that's not relevant because they don't have a burden beyond a reasonable doubt to prove somebody did this. They have also cut off benefits and been wrong before and had to restart those benefits. They are not always right. So to tell the jury, you're basically entering the province of the jury. It's the ultimate question in this case. Did Lori Vallow do it? Because if she did it, they'll cut off the payment. Yet Lori Vallow probably didn't object to this question. The jury had the question, and this person answered the question. This special agent answered the question. From my perspective, I don't think it was an appropriate question to ask this witness because I don't think it was relevant. Is it true? Yes, of course. I know, and people are going to get mad at me that I would say I would object to that question. I really don't think that is a relevant question to prove this crime. I think this is up to the jury to decide whether or not she did it. But it came in. And from my perspective, that is incredibly damning. I do not think this is the strongest case in the world from the state. I don't think this has been the strongest presentation of evidence in the world in this case. But I do think the fact that Lori Vallow is representing herself has given the state an infinite amount of leeway to prove this case in a much better manner than they would have without Lori Vallow representing herself. I think that question's objectionable. There are more questions coming later that are similarly damning that I don't think should have been asked in front of the jury. Because now the jury's hearing these people that do this for a living and figure these things out, they found that Lori Vallow did it to Charles just to get the money. So what am I going to say? The special agent is wrong? That's a mistake. Also, there was so much leading yesterday by the prosecutor with no objections. And you can notice, if you're wondering, man, this is really going smooth. She's doing great. She's getting in a groove. All these witnesses are picking up what she's putting down. There's no confusion. That's because there is so much leading. So much leading. And when you're allowed to lead a witness, especially when they're a friendly witness to you, life is so easy. You can tell the story exactly how you want to. Special agent, you did this. You guys do your job, right? You guys don't take it easy. You guys XYZ. Witnesses are literally saying correct to her. When we get to even the last witness today, she said it multiple times. This is what Lori Vallow chose, and it's her right to do it this way. But I think she has seriously helped the prosecutors. Okay, I actually wanted to listen to some of the follow-up that happened after this jury question as well.
And during your investigation, do you know if Lori Vallow notified Social Security of her new marriage?
She did not.
So that's another one that I would object to. That might be more relevant as far as her mindset to want to keep collecting Social Security. So from my perspective, I think that one is relevant to her mindset that she did want to continue to get Social Security and was only telling them information that would get her money. I do think it's relevant. I still would have tried to object it to fight that it's not relevant. It's way more prejudicial. It doesn't prove whether or not she committed this crime against Charles Vallow, but to me, it is relevant to some of the other crimes. So I understand why that was asked. And guess what? Where does that tell you that the jury's thinking? The jury's thinking Lori Vallow set this all up to marry her new husband and take her old husband's money. The motive is crushing Lori Vallow. The story tells itself. It's just too perfect. It fits in line just too perfectly. And the state has been smart to focus on that motive as their best evidence.